Okay, good morning, everyone. This is Matt Braden from the GPAR professional staff. Hope everybody had a great weekend. Here we are with our next coffee talk, which we're coming back on a little bit of a sabbatical. But before we get into today's conversation, just a couple of housekeeping items for the association. Please mark your calendar. Friday, October 18th, we're going to have our annual general membership meeting at Live Hotel and Casino. So we're returning back to that venue for our third general membership meeting there. More information will be coming forward from the association. We'd love to see you there. It's always a great time to meet up, network, have some great speakers. That will be again the morning of Friday, October 18th. Looking ahead to later on this week, Coffee Talk, another one. So we're doing 2 hits of Coffee Talk this week. Wednesday, 10 a.m. Council member Isaiah Thomas will be chatting with Chris Mattioli, our president. So we're going to talk about things going on in City Council. They just came back from their summer recess. Lots of stuff going on. So we'll be catching up with all the activities going on in City Hall. That will be Wednesday, again, 10 a.m. Check your inbox for registration details for that. September, Realtor Safety Month. So there's 2 safety webinars that are in the pipeline. One is from PAR, Pennsylvania Association of Realtors. That's Thursday. Check your inbox for messages from the association about that. We'd love to see people get on there for that webinar. And then on September 18th, NAR will be hosting one as well. So 2 webinars related to Realtor Safety Month. Please check that out. We'd love to see you guys there. So with that, let's turn it over to our president, 2024, Chris Mattioli. Good morning, Chris. How you doing?
Good morning, Matt. I am still in recovery. I've been a little under the weather for the last few days, but I'm excited to welcome everybody to Coffee Talk today. Today's special edition, obviously hosted by GPAR, is going to be an insightful conversation with, our gentleman here from Bright MLS, our distinguished guest here. We've got Rene Galicia, who is the Executive Vice President of Customer Advocacy, and Brian Schneider, Legal Counsel of Bright MLS. So obviously a lot of important topics today impacting our industry with the recent changes from the NAR lawsuit. And, these changes potentially are going to reshape how we work, and it's critical for us to have a strong understanding and how it affects our day-to-day business. So thank you both for taking the time, gentlemen. I'd like, welcome you, but then hand it off to you guys, and have progressed since that, transition date of August 17th. So welcome.
Thank you. Good morning, everyone.
Good morning.
I'm also getting a little better, so my voice is going to cut in and out, but hopefully I'll make it through this. Thanks for having us this morning. Let me get my screen share up, but before I do, again, very informal. I'm having coffee just like you are, so is Brian. So ultimately, we're here to answer your questions. We have some slides that we'll walk through, maybe as conversation starters and just a general update. But ultimately, we want to answer your questions, whatever is top of mind, whether it's related to the settlement, whether it's related to Bright generally. Feel free to either unmute and ask your question or put in the chat, and we'll answer that as we go. So give me 1 minute here, and I will get my slides going. Should be able to see that, and unfortunately, I only see about 3 of you now. Yep. So just unmute yourself. I probably won't see you raise your hand. I'll turn it over to Brian to get us started here.
Yeah, good morning, everybody. So, Rene and I always like to start these things just to remind people sort of where we were, to keep in mind that, things have radically changed in, less than 6 months. So next slide, Rene. I think it's just really important just to remember where we were as recently as March. It was just March that the settlement agreement was announced. Prior to that, we were looking at massive class actions. I was defending several realtor associations in those class actions. And in each of those cases, in Texas and Nevada and 24 others, there were hundreds of brokerages, some of which had fewer than 20 agents in them. And so, we were looking at massive bankruptcies. And, I think it's just important to remember that that's where we were and that the pivot was dramatic. So yes, we've got a whole new set of rules that we have to think about, transparency requirements, compensation issues, but that pivot is important because it meant that we were looking at sort of a black hole tunnel of bankruptcy and payments for the industry. And now we're shifting to how do we move forward? And, I think people who are in the lawsuits have a more reasonable, sort of perspective on that to say, gosh, I'm ready to look forward. I'm so thankful. For those of you and us who were lucky enough not to have been sued, I think it's harder for you to have that perspective. I think you're looking at it reasonably to say, well, I wasn't sued and now I have to change my business practice. And I recognize that that's probably pretty frustrating for many of you. And that's why I always sort of like to just remind folks about what we were looking at because it likely was going to keep expanding. There were new cases being filed roughly every 10 days. And now we're in a new era. Rene, next slide. So where does that put us now? So go ahead, Rene. So we obviously know there's a lot of rule changes. One thing that I always like to remind folks of is these 5 points. So you may be familiar that there are rules that the MLSs nationwide had to adopt to take compensation out of the MLS, et cetera, that you've probably read about, you're familiar with. But these 5 rules actually apply to all of you directly. And a lot of folks don't understand that, right? And now I know that all of you will. And that is, in order for you and your firm to be covered by the settlement agreement and not sued, because the plaintiff's lawyers are looking for more lawsuits, you have to follow these 5 rules. And the 5 rules are things that presumably you are very familiar with, that you've attended the trainings, you've been listening to our webinars, you know what these are. But it's really important to understand that these are rules that actually apply directly to you and your firm in order to protect yourselves from future lawsuits. Next slide, Rene. So Rene, why don't you take this one?
Yeah, absolutely. So one of the things that has generated a lot of questions is now as we start getting into the mechanics of how transactions work pre-settlement, post-settlement. And so we want to walk you through, and of course, now it's not doing the animations that I wanted to, want to walk you through very briefly, how things were pre-settlement, what you knew about, and, kind of how we see the mechanics working now post-settlement implementation. Pre-settlement, as you all know, you'd go on a listing presentation, you'd negotiate with the seller for your listing contract, including your fees, which have always been negotiable, not set by the association, not set by the MLS, not set by law. And you typically negotiate a fee for yourself and that you would offer through the MLS to a cooperating broker. You then put that listing into the MLS, there'd be an offer of compensation. I'll come back to the offer of compensation in a minute because that's generating a lot of questions. You didn't put the listing information into the MLS. Buyers, brokers would search, work with their clients, send out listing information, and an offer would be written. You'd accept an offer of compensation, you'd transact, and you'd receive payment on the buy side from the listing brokers through the transaction. Now with the settlement in place where buyer brokers have to set their fee with their buyer up front before a showing occurs, the mechanics have changed a little bit. There's no longer an offer of compensation inside the MLS. And this isn't just about a field in the MLS. Yes, we removed the compensation field, but it's broader than that. It's about facilitating any offer, any cooperative offers of compensation between brokers. So sharing of compensation anywhere in, on, or connected to the MLS. And again, the reason I say that is it means although we remove the field, it doesn't mean that you can continue to put in comments in the remarks or upload a document or an attachment or link to a page that says, here's the offer compensation. The settlement requires us to remove any and all references to sharing or facilitate sharing a compensation through the MLS. So how do things work post-settlement? So with buyers and buyer brokers setting their fee for the buy-side representation prior to the showing of a home, on the listing side, you'd still negotiate your listing agreement, you'd negotiate your fee, but now with the buyer being in the driver's seat of being responsible for the payment of that compensation to the buyer broker, there's a couple of options that they can take, a couple of paths. Yes, the settlement still allows for brokers to share compensation off the MLS. So there could certainly be a call from buyer's broker to listing broker, ask if the listing broker is offering or sharing any compensation. But generally, I think that the more likely scenario is going to be the buyer, through their agreement of sale, knowing that they're committed to paying a buyer brokerage fee, they can ask the seller to either contribute as part of concessions, whether it's closing costs, whether it's service provider fees, or paying or helping to offset the amount that they are responsible for paying their buyer broker. So buyer and seller now moving forward may negotiate for seller to cover those fees. Just like they have in the past, sellers have often covered not just closing costs, but inspection costs, repair costs, termite costs, any number of items that can be negotiated through the transaction. That is still a viable option. The important part here is putting the principals, the buyer and the seller, in the driver's seat of that transaction. Now, I use buyer and seller. Generally, this would apply for rental properties as well, so landlord-tenant applicant relationships. Same mechanics would work there. Brian, anything else here on this slide?
No, that's great.
You may have questions, and I'll keep an eye out for them in the chat, and we certainly come back to that about, well, my standard form agreement still allows me as a listing broker to upfront document buyer broker fee. How does that work? That contrasted with waiting for a buyer to potentially ask, if at all, the seller to contribute to concessions or to help offset or pay for the buyer broker fee. We can talk through that as well. I did want to mention, you're likely hearing from your colleagues or seeing online about, well, I can still offer compensation off the MLS. I can offer it on my website. I can offer it in texts or emails. And certainly the settlement allows for that. There's some caveats there, and we'll come back to that towards the end on some Q&A, some concerns and some areas of caution. But don't forget that the reason we call it an offer of compensation was it was a contractual relationship on the MLS. You all agreed to what was known as a unilateral offer of compensation on the MLS. You accepted by submitting an offer on the terms acceptable to the seller. And there was a contractual relationship through the MLS to make offers of and receive offers of compensation. Off the MLS, with that structure no longer in place, in order to have an offer of compensation, you likely have to go through you'd have to go through some quite a bit of hoop jumping. So what you're likely talking about is a desire to potentially entice or offer to pay, but nothing set in stone until you have it in a written agreement between both sides. In this case, if you're still sharing compensation from the listing side to the buyer broker, that has to be made in an agreement where listing broker, buyer broker, likely seller and buyer, everyone signs and agrees to. Otherwise, much like on a listing where you see a listing reference that seller may or may not leave the fancy appliances behind, unless you ask for those in the agreement of sale, you get what? You don't get the appliances, more than likely. So everything has to be documented in writing, agreed to between everyone. So the offer of compensation as we know it no longer exists because it's no longer through the MLS. So off the MLS, it's a desire to negotiate for that compensation.
And Rene, there's a question in the chat that's a good one. So, once this is negotiated, how does it get entered post-closing in the MLS? What gets entered?
Yeah, it's a great question. So I'll give you the longer answer. Back in June, we added on the list side, on the listing entry side, a seller concession field. It's a yes, no optional field. You can input something, you can leave it blank. concessions have long existed inside of the MLS. So these are incentives or offers from the seller to the buyer to incentivize them to submit an offer, whether it's help with closing costs, repairs, et cetera. That has long existed on listings. We just didn't have it as a structured data set. So back in June, we added a field on the listing side where you can select yes, no to help identify whether those concessions, whether the seller is willing to entertain offers that ask for concessions. At the same time, we expanded the set of fields on the closing side, where before we had one field, you input one amount. Now, understanding that these values are very important for valuing a property, for CMAs, for appraisals, we added a couple extra fields to help break down the categories of cost. When you close a listing, you have a couple categories of concessions. One of those is a seller concession towards closing costs or other costs. That's where you can input if there were some certain fees provided towards buyer brokerage, for example, service providers. You can itemize those on the closing side. Because those are not offers of compensation, those are reporting concessions or costs from seller to buyer as part of the closing. That's the appropriate place for those. You would not want to, on the listing side, write in that there's an offer to cover buyer broker fee. The seller can certainly offer overall concessions towards, the buyer really ultimately chooses what those concessions will apply for, or they'll make an ask. But on the closing side, that's where you can document what was paid towards buyer broker's fees in that seller closing costs field. All right. I went back too far. Before I go on here, these disclosures and agency representation documents get signed with tenants? Yes. Do these requirements apply to commercial sellers? No, generally, although you can certainly use the form if you'd like to for disclosures. Buyer, landlords, and tenant. Yes. So let me, as I answer this question, I'll put a link in the chat. So we're talking about the Bright MLS disclosure form that we published that's required for use on each transaction. Through the settlement, we're required to ensure that you provide certain disclosures to your clients on both sides of the transaction, whether it's a seller or landlord or buyer or tenant applicant. Let me grab that form here for you, and I'll put it in the chat here. So we have a one-page form that you can use. It's available also through your form management providers. So DocuSign, or not DocuSign, and none of the names escape me. So SkySlope, Lone Wolf, Zip Forms, other major providers, you'll find those in the library. And here is the link. I'm putting that in the chat. Now, when you get this form signed or initialed, you don't need to submit this to Bright. Just have it in your file as part of your transaction documents, and that'll help you stay in compliance with the terms of the settlement as well. This form is really two parts: one for use with your seller or landlord, and one for use with your buyer or tenant applicant. You'll also see a second page here, which leads me to this next portion of my slides here. One of the other things that we did in August 14th, when we updated our rules, is we had a number of rule updates on roadmap. And rather than do a rule change in August and then come back and do another in September or later, we released and updated a couple other rules to help simplify the way you submit listings and to get us away from thinking, there's been a lot of talk about mandatory submission and office exclusives and clear cooperation policy. And that's all great talk for us policy nerds. Really doesn't help in having the discussion with your sellers. That's not the way they think. So we simplified our rules, and really the best way to think about submitting listings to the MLS is a two-step process. And as I go through this, we're really talking about three different rule sets, but we've simplified it down here. These next two slides will walk you through what to do when you have a listing. Do you have to submit it to Bright? If so, when? So two-step process. The first step is just to ask a simple question. Do you have a listing agreement? If the answer is no, then cool, we're done with this two-step analysis. The Bright MLS rules don't apply. If you don't have a listing agreement, there's nothing to submit to Bright, nothing to do with our rules. But if the answer is yes, And again, you'll see this reflected in that second half of the disclosure form that I just linked in the chat. If the answer is yes, the next question is, when did the seller instruct you to let potential buyers or renters learn about the property? Now, typically it might be today, right? If you sign the listing agreement today, seller may say, get the listing, get the property on the MLS, get it on the internet, get it sold. I need to move, start telling folks about it today, put the sign up, do the open house. Then if the answer is today, then you have to submit it to Bright within 2 calendar days. Now you might be asking yourself, well, what if I have a office exclusive, something else? Let's hold off on that question for the second part of this 2-step process. All we're asking here is, when did the seller instruct you to let potential buyers or renters learn about the property being for sale or for rent? Again, if the answer is today, input it within 2 days. If the answer is a future date, then you input that listing to the MLS 2 days from that future date. So as an example, you sign a listing agreement today, seller says, don't tell anyone about it yet. I want you to have the professional photographs and the floor plan and the full marketing material in place. Just hold tight. Let's get it on the market, a week from today. Then you would input that listing into Bright within 2 days of that future date, right? Once you have your pictures, everything's ready to go, then you put it into Bright. Now, the second part of this 2-step process, if my slides will cooperate here, is once you submit the listing to Bright, how do you categorize it? And how will you distribute that listing through Bright, if at all, right? And there's really 5 options here. The majority you know about. There's one that's kind of newish as of the beginning of the year, and I'll walk through them here. So you've got a listing agreement, you know when you need to submit it to Bright. Now, how do you categorize that listing? The first step here, or the first option, is where a seller is ready for showings. They want the listing fully distributed to the internet. This has been the longstanding default at Bright, which is you input the listing as active with internet distribution set to yes. You submit the listing, it goes out to over 22,000 IDX websites, all the syndication channels, gets shared with all the other subscribers within the Bright search system. That's the full distribution of the listing. The second option is for a scenario where we were just talking about photographs. Maybe the seller says, go ahead and put it on the MLS. Tell others about it. Start scheduling the open house, build that interest, but don't publish it on the internet yet because we don't have the pictures. So we don't want to hit send. We want to share with other subscribers, but we want to let them know that it's the photographs are coming, or any number of reasons. In that scenario, you can select to enter it as active with internet no. With internet no, it will only be distributed to Bright subscribers within the Bright search system, but it will not go out via the data feeds until you switch that listing to internet yes. This is also a great use case scenario where you have somewhat a sensitive transaction where the seller has asked you to manage the publicity on that listing, or who knows about that listing. Certainly you can make it available to other subscribers, but manage how you share it externally or on the internet, if at all. And again, that's active internet no. The next 2 options are related to coming soon. And this is where we made a change on coming soon. So the third option, the middle option here on the screen, is where the seller is not ready for showings, not ready for open houses or any tours, but wants the listing distributed to the internet, right? They want publicity on that listing. They want all subscribers to know, and they want it on all the websites. Then you can input it as coming soon with internet yes. The second option is coming soon with internet no, similar to what we were just talking about with the active status. The change here is that coming soon used to have a limit of 21 days. If you had a listing in coming soon status, it can only stay in that status for 21 days. Then you would have to switch it over to another more applicable status. That 21 days was kind of arbitrary. It didn't have that flexibility that you all need to work with each and every individual transaction. As you all know better than we do, every listing operates differently from the next. And so what we were finding is that 21 days was not working in many regards. It was forcing agents and brokers to decide what next best status would work for this listing. So we've removed that 21-day limitation. The listing can stay in coming soon status with either internet yes or internet no, as long as that property is in fact not available for showings, not available for tours or open houses to anyone. once it is available, you can switch it over to active with either internet yes or internet no. And then finally, what if you have a unique scenario where the seller doesn't want the listing distributed through the MLS at all? They've signed a listing agreement, but they've got privacy or safety concerns or any reason why they don't want that listing shared with subscribers or the internet. Then that's what you've traditionally known as the office exclusive. In January, we retooled our system to allow you to input those listings. So you can document all the information, but it would not be shared with other subscribers. So you input that listing as normal, you select that it's an office exclusive in our system, and when you hit submit, it will only be visible to you and your broker. It will not be shared with subscribers. It will not be made available in the data feed externally. This is the other change that we made. If the seller has instructed you here not to share it through the MLS, they may want you to facilitate marketing or distribution through your own networks, through your own marketing mechanisms, et cetera. That would be perfectly acceptable under the revised rules here. This instruction here is only about no distribution through the MLS, either through our search system or through data feeds. Brian, anything else on here?
Well, yeah, I just note that, I think this is a pretty unique set of flexibility, both on the coming soon and the listing entry piece. And, I think I like to remind folks that, the requirements around compensation and new contracts, disclosures, all of that is obligatory. We had no option but to implement those under NAR's edict from its settlement agreement. And so as we looked at these changes, what Rene and the team tried to do was say, okay, how can we make sure that we are maximizing flexibility otherwise, outside of what we're required to do under the settlement agreement, to give Bright subscribers the flexibility that they want? And so, they looked to agents and said, okay, what are the things you are frustrated by? What is the flexibility you want? Where are we imposing requirements that we could be more flexible on? We looked at that feedback and said, all right, well, these are the things we have to do under the settlement agreement. We have no choice. But here's where we could implement more flexibility. And so that's where this is all coming from, is to try to say, all right, let's support your marketing strategies with ultimately the goal of supporting cooperation among brokers on behalf of their clients.
Thank you, Brian. Added a link in the chat to a page on our site that has a lot more information, and you'll find a link to this flowchart as well as a previous recording that Brian and I put together. So if you have other questions or want to get a copy of this two-step process here, you'll find that on that page that I just linked in the web chat.
There's another question in there, Rene.
Yes.
About if a seller asks you to show a property to a particular person before putting it on the MLS. Obviously, if that person is represented by someone from your own brokerage, that would fall under that office exclusive category. But this question has come up before. What if it's not? If I'm listing the property and Brian lives next door to you, and you tell Brian, and Brian's brother has an agent with another company, and we're making some painting updates and we're getting the pictures done, maybe even staging the property. Can you talk about how that should be handled a little bit?
Yeah, absolutely. And thanks for asking that question, highlighting that's one of the reasons we wanted to update, clarify our rules, and that these are very real scenarios, right? I'll give you an anecdote from yesterday. My wife and I were out walking yesterday, and we happened to cross the neighbors 2 doors down, and they came out, said hello, and mentioned, "Hey, we're getting ready for our yard sale next weekend. You guys are welcome to stop by. And by the way, we're listing the property we're getting ready to move," right? And now, if you're a listing broker, you're wondering, great, what do I do now? Is that clear cooperation policy? They just told someone out. That's not the way we want rules to work. We don't want to restrict anything or prevent you from adequately serving your sellers or your buyers. So the question, I think, maybe has 2 parts to it. One, in your traditional office exclusive scenario, the instruction there from the seller is about distribution through the MLS, right? There's no restrictions with our updated rules now on Can I tell my brokerage? Can I tell the neighbor? What do I do if the seller starts telling the neighborhood that the property is for sale? The office exclusive instruction is just about not distributing it through the MLS. You still have to file it with us, but it won't be distributed through to other subscribers or through the data feeds. Unique scenarios, privacy, safety concerns, any number of reasons. If the question is about coming soon, and the seller says, okay, you can tell people, but limit how you manage the showings, then if that property is available for showings, you just need to manage it appropriately, whether it's certain dates or times, et cetera. It should not be incoming soon because it is available for showings, whether it's to someone within your brokerage or outside your brokerage. You can have information about, and there's appropriate selections within the showings field, call before showing, appointment only, et cetera. You can manage that through the system today. If that property is not available for showings, maybe for a week or two, you can have it incoming soon. And if someone wants to see it, get them scheduled, and the system allows you to preset showing appointments in the future after a certain date. You can manage it that way. So really it's about, is it available for showings today? Yes, no. If it is right now, later today, then put it in a status to make it available to everyone else. Keep in mind, it's, you're also, this is part of the broker cooperative, right? Sharing information with others, facilitating showings. You're ultimately furthering the interest of the seller. And if it is available for showings, great. We have a status for that. If you need to manage how and when showings occur, there's appropriate selections within the showings field to help facilitate that as well.
Thank you. One other question you mentioned about the internet. That new status, could be active but not on the internet, and then coming soon and not on the internet. Are those going to be searchable
Yes.
categories for the agent? Okay, so we'll see that.
So I'm sorry, are you asking about, is the property searchable, or is it searchable whether internet distribution is set to yes or no?
Yeah, whether it's internet searchable, yes or no. So will I be able to see, if I run a list of properties, I'll be able to see, okay, this is active, but it's not yet published on the internet, correct? I'll be able to see that either in the one line or in a detailed report.
That's a great question. I don't know. I will try to find out here next time Brian speaks. I'm going to run in and see if I can look that up, and I'll confirm for you. I'm not certain if we have that as a searchable field. It makes sense that we would. So I'll confirm for you, hopefully before we wrap up the call here.
Oh, wait. So are you saying, Chris, are you asking whether I can see in the system that someone has said internet no?
Correct. Like if I'm
I misunderstood your question. Yeah.
Yeah, if it's published to the subscribers but not to the public on the internet, that means if I look it up, I'm going to see Rene's listing. But I'm just curious if I'm going to be able to tell whether or not, is that being published out to all the other websites?
Yeah. Okay. Got it. Yeah. Thanks for the clarification. I was misunderstanding your question. Right. So the question is, yes, if it's internet no, you can see it in the system, but can you see that it's internet no? Okay. Got it. Yeah. I don't know the answer to that either. It's a good question.
Thank you. Sorry. Go ahead, Rene.
Yeah. So while Rene's looking that up, I can jump to the next if you want, Rene. Yeah. So, we conducted a survey of brokers across the market in the last 10 days. And we were kind of pleasantly surprised, to be candid with you. I think the general themes were actually quite positive. There's absolutely hiccups going on. There were comments about, folks not understanding compliance, folks still needing more education. But, they acknowledge, Rene and his team were able to reach 70+% of the 100,000+ subscribers in the last 2 months to get training done, which, 70,000 subscribers to get through these trainings is quite a feat. And I think what brokers were saying was, yeah, we saw that and our agents were largely prepared. What we saw in the data in the survey was that folks are still trying out a mix of compensation practices, whether it's, getting their sellers to authorize continued offers of compensation on listings that were already out there. My sense from the survey data is that newer listings, the listings that were signed after August 17th, have a much lower rate of a blanket offer of compensation. It's much more common that the seller is saying, come to me with a request in your offer, and I'm happy to consider covering the other side's costs. That's what the agents and brokers are training their sellers and buyers to think through and negotiate. We're seeing a lot of updates on forms. I've seen in the survey data a number of brokers saying that they have created their own forms using some of the sample forms that are out there. That they found that some of the standardized forms weren't customized enough for them, and that they wanted better communication with their clients. I think as I looked across the forms, and as you've seen some of the reports nationwide, there's still a lot of criticism out there around standardized forms in terms of consumer readability and legal liability management. And so, this is the time to test things out and figure out what is the communication you want to have with your clients as in your firm, and are your forms supporting that communication? And if not, give your associations feedback on how to improve those forms, or have your brokerage, update them internally. That you are allowed to do that. You got to make sure you do it right. You can't just do it ad hoc. You can't do it with, a pencil and, an eraser, but, when done right, that can be very helpful too. And I think, finally, the survey we did, by and large, almost uniformly said, business is getting done. We're getting listings closed. We're getting new listings signed. There is rarely, according to the survey, a real issue in being able to continue doing business, even in the last 3 weeks, 4 weeks since the turnover. Of course, this is all new. The data is very fresh. The changes are fresh. So we're going to continue to monitor, continue to survey. But right now, what we're seeing generally is folks saying, we're figuring out how to do this. It's not easy. We're getting, several people said my phone has been blowing up because people didn't realize the changes were happening. I sort of question how they could have missed all that, but they did. But now it's getting fixed, right? Folks are realizing what's going on and adjusting, appropriately. Next, Rene. In that data, I think, just real quick, what we saw was some real satisfaction, which was nice to see with Bright's training and readiness. If you follow Bright's Facebook pages, there's, some loud negative voices, but I think when you actually just look at the data, the vast majority of Bright subscribers are recognizing that this is, something Bright had to do, and was satisfied, and also was satisfied with the flexibility that Bright added, at the same time, and sort of rolled out the ability to, have to be tighter here, but be able to be looser there. But I think, the data says that folks recognize that and appreciate it. Folks are concerned about some agents out there, brokers out there not complying. And I think, that will shift. And I think, there were several comments that private exclusives are not in the consumer's interests. And that was an interesting observation that it'll be interesting to see, as brokers decide how to use that tool, particularly the way that Bright now, is allowing you to use it. Look, if you're marketing it publicly, it should be active, but Bright is saying, they've made the decision that you don't have to. You don't have to make it active if your seller is saying that they don't want to have it distributed in the system. But it should be, right? From a maximizing your seller's interest perspective, there's good data, there's good experience to say active in the MLS does the best job. And I think, it's reflected in the data that the brokers are saying, we're just not sure why folks are considering these private exclusives in the way they are. Next. So what comes next? And Rene, while I cover the next slide, you might want to look over that. There's a couple questions in the chat that could be good for you to answer. So what comes next? So, we're past the August 17th date where, effectively every MLS and every realtor in the country had to, make its shift. We've now got a few months to sort of settle in. The next date to watch for is November 26th. So, right around Thanksgiving is the hearing in Missouri before the federal judge that is overseeing the whole settlement, that oversaw the trial, and that very much wants the settlement to be finalized. Every indication is that the judge wants to approve this settlement. But there's the opportunity between now and then for folks to comment and submit papers to the judge saying why they do or don't think the judge should approve the settlement. We fully expect the Justice Department to file a paper sometime between now and then saying why they think offers of compensation should not be made, period. They've said this 3 times so far already publicly. We fully expect them to file a paper in Missouri before November 26th saying that blanket offers of compensation should be banned. The NAR settlement does not ban it. No rules ban it. No MLS is going to ban it. But the Justice Department wants it banned. And you should just expect that you're going to see headlines like that. It doesn't mean that it's happening. The Justice Department can't force it. They have no power to force it. And the judge is very likely not going to add that to the settlement agreement. We fully expect the judge to approve the settlement agreement as it stands. But that's what we're watching for over the next couple months. Next slide. We're also watching that, there's still existing legal attacks out there. Things are not over, so to speak. There are still class actions out there that are wending their way through the courts. It's much, much less significant in terms of dollars and the number of defendants. It's much less threatening to the whole industry, but it's still out there. There's a class of buyers that want their share of payments. People, the settlement so far is about sellers. The buyers want their pound of flesh as well. And of course, their attorneys want their pound of flesh as well. The Justice Department is sending out new subpoenas every month to MLSs, realtor associations. They are still fighting to be able to investigate NAR. And they're focused on a number of policies that they want changed. They want more transparency in the market. They want less restrictions by MLSs, by NAR. And, I think ultimately the changes that we've made at Bright already get ahead of any of those issues. We've already implemented a lot of the flexibility that we think is appropriate. And so we're in a pretty good shape in this market. We don't expect to have to make more changes at this time, but we're watching because you never know how the Justice Department is going to pivot. And then lastly, look, there's challenges to the system of cooperation. There are several commentators who believe that the Justice Department or state attorneys general may actually start attacking the notion of cooperation, the notion of the MLS in this, sort of so-called, internet age. Will they undermine the ability of folks to actually, share information on behalf of their clients to further their clients' interests? I'm skeptical. I don't really see certainly as an antitrust lawyer, I don't see an antitrust claim there, at least under how we're operating today. But, you all need to make sure that you understand that this industry is under scrutiny and that if games are played with compensation in particular, we're just asking for more attacks. Rene? I think I covered these. I think that we're good. Back to you, Rene.
Thank you. Chris, I did check. Currently, internet yes, no is not searchable. But I'm going to chat with the team and see if there's a reason why it shouldn't be. So I did try a couple different ways and I wasn't able to come across those. So we'll more to come on that, on whether or not we can add that field. By the way,
if it's not searchable, at least identifiable in somewhere on that document, on the MLS.
Yeah, absolutely. So we'll I'll get back to you. I'll shoot you a note on what we find here on getting that added. And by the way, for everyone, right? Anytime you see a use case for, can I do this in the MLS? Can I see a certain field? This is exactly how these requests are made. Nothing fancy is required. Just shoot us a note, send us whether it's someone on staff, you can call into the support team, speak to a member of the board of directors. Anyone connected to Bright can send your request, and we process hundreds of requests for system enhancements, all from subscribers. We love to hear that, so send them our way. I'll go through a couple of the questions. I think I answered this one previously, but just in case, can the amount of concessions a seller is willing to offer be specified in the remarks? Yes, with some caveats. we define concessions as incentives from the seller to the buyer. Concessions is not a replacement for shared broker-broker compensation. Additionally, under the terms of the settlement, you can't condition a listing on the offering of concessions. So with all that in place, yes, if a seller wants to incentivize, they've selected the yes, and they want you to add in description in the remarks, totally good. Again, incentives are concessions are seller to buyer incentives. What you want to avoid though is restricting or classifying and saying, seller paying buyer broker compensation, this amount. Keep it at the concessions level. Let the parties negotiate. The buyer may ultimately decide that they don't need help with buyer broker fee. They may have negotiated something unique to them where maybe they want to take advantage of concessions for a rate buy down or repairs or something like that. So okay to list or reference in the listing, just don't constrain it to compensation. Josh asked, related to the MLS disclosure form, on the second half when you're managing a listing, there's a question that asks, when will your broker allow potential buyers or renters to learn about the property? And Josh asks, what date would you like to see in question number one? If you're asking me, ideally, the date that you sign the contract. But ultimately, this is a discussion for you and your seller. Once you sign the listing agreement, are they ready for you to let let potential buyers know about that property? If the answer is yes, then you likely have that same date as when they're instructing you to input the listing to the MLS. If there's a reason to wait, staging, there's an illness, any number of reasons where they want to delay when you begin telling potential buyers about that listing, you're preparing some marketing material, et cetera, then it could be a future date. That's ultimately between you and your seller. You can always amend that and modify that. So if seller says, hey, don't tell anyone about the listing for a week, that'll give us time to get photographs in place, get the staging, and you have a great service provider and they pull through in a day, you can always amend that and submit the listing sooner than that, or later, whatever the case may be. The goal here is to give you all the flexibility to work with your sellers and make the distinction between preparing the property for sale and actually beginning the process of selling the property.
Rene, can you just
Rene. So I deleted there was one question in the chat that I deleted just so folks know because it included specific percentages of compensation and such. We always have to refrain from sharing any particular percentages just to avoid the antitrust risk. But I'll answer the question generally. And the question was, if the seller is making a blanket offer and what the buyer agent has agreed that they will earn in the transaction is less, what happens? And the answer is twofold. One, it's up to negotiation. If the buyer's agent wants to go back to their client and say, hey, look, the other side is saying that they'll cover more, will you allow me to receive that? That's permissible, but the buyer would have to agree in their contract to let you keep that. And if I'm a rational buyer, I'm going to say, no, we agreed that you earn X. Just because the other side is willing to pay more, that signals to me that they should give us more concessions in the deal. I want that extra amount, or I'll split it with you, or, whatever. So it's up to negotiation. The second part of my answer, though, is that's why I don't think blanket offers are going to be widely used in the coming months. I think for now, there's a lot of tendency to sort of stick with the old system, and because you're comfortable, and I get that, I would be doing it too. But I think as you get used to sort of the new system, those kinds of negotiations are going to lead you to advise your seller rationally. Don't make a blanket offer. Let's see what the other side comes with. Let's see how many offers we get from various potential buyers, and let's see what they're asking for, because some may be asking for less and some may be asking for more. And let's see what the total package is that you're able to get as a seller. Let's not make a blanket offer. The corollary to that is, you absolutely as a seller can indicate to the market that we understand that we will cover some of the other side's costs. You can do that in the MLS by checking the box that you're willing to offer concessions to the other side. You can put it in remarks that you're willing to cover buyer closing costs, right? Those are all acceptable items. And so as a result, you can signal to the market, we get it. We're willing to give some concessions. And, concessions as a term is broad, right? It's covering the other side's costs. It's, cash towards closing, it's finance costs, all those things. You can put all that into one statement. We're willing to cover some of the other side's costs. So that's, I think, the long-winded answer to your question there. And the related question, which someone just, proposed is, well, can I tell my seller in the listing contract that the seller is willing to pay up to X% depending on negotiations? Of course, you absolutely can prepare your seller client that they should be prepared that whatever their list price is, whatever the price they're expecting to accept is not the cash they're going to get at the end of the day. And here's why. If you want to have that conversation with your client, explain to them, right? There's the fee that goes to you as the broker. There's the concessions and negotiated costs that you may have to cover for the other side. And it all depends on what happens with negotiations. Absolutely. The corollary, though, to this question that's in the chat is, well, what can you communicate to the other side? So let's say that your seller isn't willing to make a blanket offer, but says, yes, I understand. I'm willing to cover up to X% if the other side asks for it. Now the buyer broker comes to a showing or calls you up and says, well, is your client willing to cover some closing costs? Well, you're representing your seller. Can you tell them the full amount that you're willing to cover, knowing that that's supposed to be up to negotiations? I don't think so. I don't think you can disclose that. I think it's not in your selling client's interest to disclose that. I think you have to say something like, yes, my seller understands that they are going to be asked to cover some closing costs, put it in the offer, and we'll consider every proposal.
All right.
So Brian, based on that, it seems like you're leaning more towards, concessions in the agreement of sale, not the CBC, not the cooperating broker compensation form. Because the CBC would have to be signed before the actual offer is made. Buyer's agent reaches out to listing agent signs and sends that over and confirms what that is. And I know we're seeing that in some other parts of the country. Is that what your data is telling you so far, that our expectation should be looking at it that way?
So I think the buyer compensation, the buyer broker, the broker to broker compensation form is going to be useful for a few months. That's what we're seeing in this market and around the country. That as folks figure out how to manage the new system, particularly listings that have been on the market maybe for a few weeks or months, where the expectation was that the seller was sort of ready to pay the other side a blanket offer, that form is going to be helpful to manage and make sure it's binding and that everyone gets paid in the end. What I'm seeing that brokers are saying in the survey data we put out, what I'm seeing talking to MLS executives around the country is that that's just not going to get used in a few months. As this market evolves, as brokers learn about using the new system, the expectation is that's going to be pretty rare.
Gotcha. And I saw the comment in the chat already, and I just want to be clear for our membership. It seems like very similar, but it's a very different scenario of seller paying listing brokerage, seller paying buyer brokerage through the CBC, as opposed to seller paying the buyer in an agreement of sale and a buyer fulfilling their obligation to the buyer agency contract, right? There's that difference in trail. So to your question about, I think it's Naveed put that in there. Absolutely. If you have a offer of compensation from the seller prior to your showing, you need to get that CBC signed, and that eliminates that negotiation for your fee anymore. But that doesn't mean the buyer can't ask for that. And if that is not signed, you should already have a buyer agency contract executed that the buyers agreed to pay you a certain fee, that buyer can negotiate with the seller to get that concession for that. I hope that makes it a little clearer. I think Brian was going back to you, Rene. I just wanted to answer that one.
Yeah, absolutely. And you were cutting out a little bit, but I think we got most of that. And just to add on that cooperating broker compensation piece, I think the other reason, Brian, and just to underscore, the feedback that Brian's been hearing and from across the country and other MLSs and other practitioners, is that the cooperating broker compensation form or that discussion presumes that brokers are still sharing compensation, but a little bit ignores that it's the buyer that's on the hook for paying that compensation. And so really what we're starting to see in some markets, especially those that launched these rules earlier than we did, it's really the buyer that would be the one seeking from the seller to help offset or cover either in part or in whole the fee that they've agreed to pay their buyer broker. Don't forget that as part of the settlement, you have to agree to a maximum amount, or you have to agree to an amount that you're going to be paid by your buyer for your buyer broker representation. And the amount that you agree to is the maximum that you can be paid from any source. And so in those discussions, I think that's where you tie in the concessions discussion a little bit better. It's the buyer's in the driver's seat, right? They're on the hook for paying these amounts. Discussions about cooperating broker compensation before offers are submitted likely premature or not placed right in terms of the mechanics of how the transaction will unfold. Just taking a quick glance here. What do you do when a seller's commission to the buyer's agent differs depending on the offer? For example, a buyer agent submitted the co-op broker compensation and seller refused to sign it until the offer was received. I think that ties in a little bit to what I was saying, in that really, I think the seller moving forward, the presentation of offers to a seller that include and ask for concessions, or where they need full awareness of what the bottom line number is going to be, what their total costs are. I think that's a better flow for how these discussions and transactions are going to unfold, rather than agreeing up front to payment of a fee without seeing an offer. Again, it's the world we just came from, and it makes sense that we're having these discussions still, and they may linger for a little bit. But moving forward, I think for the sellers anyway, it makes sense for them to have the full picture of what costs come associated with the offer that they're going to be receiving. The true bottom line number, just like they would be seeing for requests for repairs, for rate buy down, for closing cost assistance. Same here with covering buyer broker fee, if at all. All right, and I'm going to maybe take one or two more. I've got a 10 o'clock that I have to jump over to. Brian, unless you have a
Thanks, Rene. And I'm sorry I'm having some if you're getting all this, but I know we're up on time.
Yeah, absolutely. We're happy to, if you still have questions, feel free to send them over. We're happy to do a follow-up Q&A or send some additional information. You're going to have questions. Please keep them coming even after the meeting here today. We're always happy to come back and have some coffee with you all and continue answering the questions. Matt? Thank you, Katie.
Thanks, guys. I'm not sure if you could hear me or if Matt jumped in, but I'm having some connection issues. I apologize. But thank you, everybody.
Yeah, thank you. Good seeing everyone.
Thanks, everybody. Cheers.
All right. Thanks, everyone. Have a great Monday. Great turnout. And thank you, Brian, Rene, and Chris. Everybody have a great day. Remember, Coffee Talk. Isaiah Thomas, council member, joining us Wednesday at 10 a.m. All right, guys. Take care.
You're welcome.